Good morning and welcome. Good morning. I'm Administrative Law Judge John Johnson. I'll be the lead ALJ for this hearing in the appeal of Katzir. I want to thank everyone for joining us today. I'd like to remind the parties that today's proceedings will be live streamed on YouTube. The video recording is part of the public record and will be available online. In light of that, just please be aware any information you share during this hearing will be publicly viewable. Before we go on the record, I'll go over a couple announcements and recap where we are following our pre-hearing conference. During these few minutes while we're off the record, please feel free to interrupt me as we cover these topics if you have any important updates or changes since the pre-hearing conference. It looks like we have everybody present that we're expecting. We'll do formal introductions once we are on the record, but if at any time we're missing someone or someone gets dropped, we lose connections, please interrupt and let me know. Today's hearing is being recorded and transcribed electronically. To help ensure we create a clean record today, I ask that we all mute our microphones whenever we are not speaking. That's going to be Alt-A, or if you're on an Apple or Mac device, Command-Shift-A. I want to also be sure that we all speak one at a time to avoid speaking over each other. That's kind of particularly important when we have multiple participants joining from the same device. Similarly, please wait to respond to prompts or questions until the previous speaker has completed stop talking. And finally, speak clearly and loudly at a comfortable pace. When needed, I or any of the panel members will interject to ensure proper transcription. As a reminder, this hearing is limited to a severed issue on appeal. That severed issue is whether appellant's claim for refund of interest is barred by the doctrine of res judicata. We discussed that a little bit at the pre-hearing conference. I know the parties were going to confer after our pre-hearing conference to discuss that topic of res judicata. I'm not sure if you were able to. Hopefully you were able to meet and talk. But I do want to ask if there's any questions about what the issue that we'll be discussing today is. Appellants, do you have any questions about the res judicata and that issue before us today? No? Okay, I see a head shake. Okay. There is the subsequent question, if we get to it after this hearing, of whether appellants have shown respondent erred in refusing to fully abate interest for the 2007 tax year. But again, all those kind of factual discussions over that interest abatement and delays and such is not part of this hearing. We'll just be focusing on the res judicata issue. On to the exhibits. From the pre-hearing conference, we noted that respondent submitted with its brief exhibits A through J, and appellants had submitted with its brief exhibits that we labeled as 1 through 5, plus a subsequent submission that came in 28 pages that we labeled as exhibit 6. I will ask appellants, do you have any additional exhibits that you're hoping we consider? And I think you might be on mute if you are.
I'm more detailed that I summarize the concept of what is the text should be.
He has a statement he'd like to read.
Okay, we could, as part of your presentation, once we go on the record, if you want to be the record.
Okay.
Does that make sense?
Yes.
Okay, great. Yeah, we'll have time for that. Statements, testimony, arguments, those can all be part of your 15 minutes that we get to later. And respondent, did you have any additional exhibits that you were intending to submit?
Do you have anything else?
No, nothing additional. Thank you.
Okay, thank you. Any objections, respondent, to the exhibits submitted?
No objections either.
And same for appellants, any objections to the exhibits?
I don't think we received any kind of objection evidence.
Okay, yeah, the exhibits I'm mentioning are just the ones that FTB had with their brief that they submitted. They label them A through J. I'm just wondering if you have any objections, you think that any of those exhibits are not relevant or shouldn't be considered for any reason.
Again, I don't think we received them.
Okay. I know at the pre-hearing conference, we also mentioned that Franchise Tax Board was going to send a copy of their brief and exhibits to appellants. Did a copy get sent?
No.
No, we did not receive.
Okay. Let's take a pause here and I'll work with my team to see if we can get a copy sent to that. I know we confirmed your email at the pre-hearing conference as well, appellants, and we'll make sure that we get that sent to you. Let's just take a 2 to 5 minute pause here and I'll let you know when we're coming back. Stay on the call, but you can mute your microphone and turn off your video for the moment. This is Judge Johnson, just cutting in real quick to let appellants know that that should have been sent to your email now. I'll give you a few minutes still to make sure you received it and look it over, and then we'll come back at 9:36.
Okay, thank you.
Judge Johnson again. Check in and see if appellants were able to receive that email.
We are going over it right now.
We received it, but it's 38 pages with lots of statutes and lots of numbers. How do you expect us to do this in 2 minutes?
Right. Well, this was the brief that was already provided to you previously
No.
during briefing process.
I don't have
Okay.
it. I'm not in receipt of it, nor have I ever been in receipt of this.
He's supposed to send, but we
He
did
was
not
supposed to.
receive
We've
it.
been awaiting it, and nothing has happened.
Okay. Let's have the parties come back.
Can you print the one and you put?
I mean, we'd like to print it and look at it, but it's 38 pages. I'm not a speed reader.
And so you're saying that you've never seen this brief before?
No, I have not. No. These are all the letters we sent, request for abatement.
The last franchise tax board, any reason why you think this would not have been sent or received?
When it was, I don't know for when it was originally filed back, would have been in March of 2024. I spoke with the appellants after our pre-hearing conference. The reason why I couldn't send it is because there's federal tax information in the exhibit list. So we're unable to send via email just because of the sensitivity for that. So I gave them the OTA analyst's name and contact information so that they could have access to the portal and request it via the portal, because I believe that our briefing or our brief and exhibit should be in the portal. Is that correct?
Are you asking us? I don't remember that.
Ask Judge Johnson.
From our end, that is correct, yes. Appellants, you do have access to the Office of Tax Appeals portal, and this document is available in the portal.
Are you asking me?
I'm letting you know that. Did you attempt to access it through the portal ever?
I don't think so. I don't know anything about a portal.
Okay.
So now what
let's-
happens? Because this is a lot of information, and
We put.
again, I'm not a speed reader, and I'm not able to read this and digest it.
Can I ask one question, please?
Sure.
On what amount of taxes they based on? What amount of tax they based on the charges? On what number? What amount? That they said they owe in the beginning, the first step, they say, okay, I owe money. What X amount of money I owe? That's what my question is.
That amount was included.
Without penalty, the day they start, they say, well, you owe that amount of money. Not talking about penalty, not talking about interest, just the amount.
When adult child franchise tax board, that amount would be the same for the notice of proposed assessment. There's been no adjustments to tax.
Exhibit E, the easiest way is Exhibit E, the notice of action, which was issued March 16th, 2018. The additional tax number of $105,373. So that was what the interest was based on from would be April 15th, 2008 until December 12th, 2022.
But what is the base? The base without tax?
105,373.
This the 105 is the base, and then you charge charge tax and penalty above it.
I'm not clear. So that 105 number is the tax. There were no penalties imposed, and then there's additional interest that was.
How much is the interest to deduct from it? How much the interest, so we know the exact amount to start with. You start with X amount of money, and then you add the interest. What is the original, the 2007, before when you start to say I owe that amount of money?
Just one moment.
Can you write it nice and clean with the pen so we're organized?
Sorry, I apologize for the delay. Some of the interest was abated, so I'm trying to find the original interest amount.
No, we're not interested in the interest amount. We're trying to find the very beginning, when this all started and you said we still owed a debt. What was that original pre-interest, pre-penalty, pre-fees debt amount?
That's the 105,000 number.
Oh, that's this one? Okay.
Mhm.
Okay, this is based on how you calculated it.
On the 38 pages of the documents that I,
Well, this-
am not a speed reader and can't read.
If I could interject, this was already covered in the first hearing and opinion that you had with Office of Tax Appeals. The amount of tax at issue has already been covered and decided in that original opinion. So this is nothing new on appeal here. On appeal here, we're only interested in interest abatement. And actually here, we're only interested in the issue of res judicata. So we're not going back and relitigating how the tax was calculated at this point.
We just want to know, can I
Sure.
write you the statement that I have and this, that's what we oppose, that amount of 105,373. Can I read it to you exactly what I wrote as a statement?
Well, let's go ahead and get the appeal going, get the hearing going, and then we'll take your statement as part of the hearing. I do want to address the issue of not being familiar with the briefing. What I will do is I'll keep the record open after the hearing, give you 30 days for appellants, and you can review the briefing in more time. You can look at the exhibits, and if you'd like to submit anything in writing at that point, you can, or if you have any objections to the exhibits at that point, you can submit them then. But I would like to keep us going forward with the issue that we discussed was going to be the issue at the pre-hearing conference.
I have a
And once we
question.
get,
I have a
okay.
question. So even if I go over the 38 pages of statutes, numbers, dates, everything, that doesn't mean anything because this hearing is only about whether we get to have a redo,
Appeal.
an appeal. So it doesn't really matter if I agree on the numbers or anything. It only matters on if I feel that the legalities have been followed in regards to the way this case has been handled. Am I right?
Well, the issue is res judicata, which is the issue of whether that original opinion that was issued for this tax year for you already decided what you're trying to argue again on this appeal.
Okay, I
That
do
kinda
have a
makes sense.
statement.
Okay, hold on. I just wanted to make sure. Okay.
So that is the issue that we're going to talk about today. The briefing is relevant because, as I mentioned, the pre-hearing conference franchise tax board's brief does cover that topic of res judicata, does point to OTA precedent about what that legal issue is. But I believe you understand that at this point that we're not going to talk about numbers, we're not going to talk about the facts of what happened in preparation of the tax returns, et cetera. We're going to talk about the issue of whether the previous opinion issued by OTA prevents this panel today from even deciding whether or not interest should be abated or additional interest should be abated. That's the topic today.
Okay.
Okay, we can continue. Thank you.
Okay, thank you. Once we go on the record, I will admit those exhibits into the record, subject to if there are any further objections, I'll consider those objections post-hearing.
Mhm.
And then once we go on the record, which will happen fairly shortly, appellants, we designate 15 minutes for your presentation. At that time, you can read statements, address any other topics you'd like to that are relevant to the issue on appeal. I'll swear you in as witnesses before then, so in case you have any factual statements you'd like to make, the panel can consider that as evidence. After that, Respondent Franchise Tax Board will have 15 minutes to present their case, and then appellants will come back to you for 5 minutes where you can provide a rebuttal, kind of address anything that was mentioned in the agency's presentation.
Okay.
If at any time anyone needs a break or you're unclear as to what's happening or have questions, you can feel free to interrupt me. I ask that the parties don't interrupt each other during their designated time to speak unless it's absolutely necessary. I will also try to give you uninterrupted time during your presentation times. With that, I believe we're ready to go on the record. Let me just check with my panel to make sure they're good to go. Visual check. Looks like we're good to go. Okay. With that, we are going on the record. This is the appeal of Katzir. It is OTA case number 2303-12870. It is 9:46 a.m. January 13th, 2026. This hearing is being conducted electronically by myself, Ministry of Law Judge John Johnson. My co-panelists today are Ministry of Law Judges Kenneth Gast and Hans Famularo. We are co-equal decision makers in this appeal. The Office of Tax Appeals is not a court, but is an independent appeals body. The office is staffed by tax experts and is independent of the state's tax agencies. The decision on appeal will be based solely on arguments and evidence provided by the parties on appeal in conjunction with an appropriate application of the law. The panel has read the briefs and examined the submitted exhibits, and we are looking forward to your presentations today. I'll have the parties introduce themselves for the records. Appellants, if you could just state your names for the record.
Jeanette Katzir, but I want to put it down that I have not read the briefs.
Okay, Omer Katzir.
Thank you. And Franchise Tax Board, if you could introduce yourselves.
Noel Garcia Rosenblum for Respondent Franchise Tax Board.
I'm Topher Tuttle, also representing Franchise Tax Board.
Thank you. Admitting into the record appellants exhibits 1 through 6 and respondents exhibits A through J. A respondent had no objections. Appellants will have time after the hearing to review the exhibits and submit any objections they may have. With that, we are ready for the parties' presentations. Are there any final questions before we move on to your 15 minutes to present, appellants?
No. You want to make a speech?
Okay.
Okay, I'm going to go ahead and actually swear you in. So if you're providing testimony, we can consider that as factual evidence. If you can raise your right hand. And do you solemnly affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, I heard it from both of you. Okay, and please begin. You have 15 minutes.
I'm going to go.
Okay.
Mr. Katzir, just very quickly, I'm sorry. I'm having a little bit of difficulty hearing you. Could I ask you to speak up a little bit or be a little bit closer to the microphone?
Okay, I'll come
Thank you.
closer.
Thank you.
I'll come closer. Hopefully you can hear me. Tell me if you're not hearing me. Can you hear me now? Okay, what I've done a summary of this issue after I look at all over the subject and the evidence that we came across to do that amount. We invest $1.25 million to the VIBA, okay? Because that's the profit we made. Unfortunately, the AIG, that orchestra, that fake VIBA, gave us only $930,000. This means not $930,000. That means we did not make profit on our $1.2 million. We made profit on $930,000. Besides it, this means they took $320,000 from my money because they said they have to pay commission to the people that we trust, our CPA, and deduct for our money. So actually, net from our money, the net profit we made is only $610,000. How did I come up with it? I took the $1,250,000 minus the $930,000. It came up to $320,000 losses from us, obviously. And if you take the $930,000 minus $320,000, we're supposed to pay taxes on a $610,000 only. The IRS recognized it, the IRS reviewed it and gave us the money back to equal the profit of $610,000. That's what we paid the IRS long ago. That's what we asked the FTB to recognize the IRS decision and help and tax us only on $610,000, not on a total $1,250,000 that original profit, because we did not profit that beside it. So however, we pay almost $200,000 overall, include tax and penalty. IRS did not charge us no tax and no penalty because they recognize the core of the root that caused the problem. This AIG, our taxman, Michael Frank, Keith Ophel, they present themselves with a fake VIBA that not even recognized by the state or by the IRS. And instead, me to get the penalties, they should get the penalties, and they should have the license revoked and thrown to the garbage because they are cause us a big pain overall, and it's not right. That's it.
All right, thank you. And anything else that you'd like to add beyond the statement?
I think what he's trying to say in his way is that if you calculate the numbers less the losses, the amount that the FTB is assessing to us is far in excess of what the IRS assessed us because they forgave us, understanding that we were the victims and not the perpetrators. And so we are asking the Franchise Tax Board to go back and take a look. And the numbers that we were assessed on are incorrect. They're overinflated. And so that's what he's asking. The numbers are incorrect. They are swayed in a way that the IRS wasn't understood and said, yes, we see that. So we asked the Franchise Tax Board to step back, take another look, and see that we're being assessed at a rate that's much in excess of what the IRS did. You do anything else? No, preaching.
And we have all the evidence. We have all
we've
the
submitted it.
numbers, everything.
All right, thank you. We'll have more time for you as well after Franchise Tax Board presents their case. So if there's anything that you hear during their presentation that you'd like to address, we'll come back to you for that. But with that, we are ready for Franchise Tax Board. I will ask first, though, since there was swearing in and testimony, FTB, do you have any questions of them as a witness?
No questions.
Okay, thank you. And let me continue then to Franchise Tax Board. If you are ready to present, you may begin.
Good morning. My name is Noel Garcia Rosenblum, and I, along with my co-counsel Topher Tuttle, represent Respondent Franchise Tax Board in this matter. The sole issue at appeal today is whether the appellants claim that they are entitled to interest abatement for the 2007 tax year is barred by the doctrine of res judicata. Res judicata is an affirmative defense developed to bar repetitive suits on the same cause of action. If a claim relating to a particular year is litigated, a judgment on the merits is res judicata as any subsequent proceeding involving the same claim and the same tax year. As held in the presidential opinion of Appeal of Millennium Dental Technologies, Inc., otherwise referred to as Millennium Dental, the Office of Tax Appeals explained that the following four elements must be met for the doctrine of res judicata to bar a subsequent suit. The parties in each action must be identical. A court of competent jurisdiction must have rendered the first judgment. The prior action must have resulted in a final judgment on the merits, and the same cause of action or claim must be involved in both suits. Appellants previously appealed Respondent's notice of action proposing additional tax and interest for the 2007 tax year. After considering the evidence and arguments presented at oral hearing, the Office of Tax Appeals concluded that the appellants are not entitled to the abatement of interest for the 2007 tax year. This decision was memorialized in its opinion issued on August 27, 2019, and became final on September 27, 2019. The appellant subsequently paid the total additional tax and interest and filed a request for the abatement of interest for the 2007 tax year in December of 2022. Respondent reviewed this request and partially abated interest. However, Respondent notified the appellants that the remaining interest would not be abated, and the appellants then timely filed this appeal. The first three elements of Millennium Dental have been met. The parties of the current appeal, the appellants and Respondent Franchise Tax Board, are identical to the parties in the prior appeal. The Office of Tax Appeals had jurisdiction to hear the appellant's previous appeal, and the Office of Tax Appeals issued an opinion holding that the appellants were not entitled to interest abatement. Lastly, this appeal involves the same cause of action as the appellant's previous appeal. Interest abatement was one of two central issues in the previous appeal, and in both appeals, the appellants repeated their argument that interest should be abated as they were victims of fraud. Accordingly, the fourth element has been met. Therefore, as all four elements of Millennium Dental have been met, the Office of Tax Appeals' previous decision is controlling, and appellant's request for interest abatement is barred by the doctrine of res judicata. I'm happy to answer any questions you may have. Thank you.
I have a question. Is there a way that you can respond without reading off a cue card? And can you respond
All right.
in plain
Thank
English?
you. We will come back to you. And please just address us, the panel. Well,
Okay,
we're the ones you want to convince, not the
I'd like to
Franchise
have
Tax Board.
answers that are written in regular English, not adjudicata. Answer us as if we're people and not reading off a cue card. Because it's as if we could have had this recorded. We'd like to know in English Why is the Franchise Tax Board saying no and not referencing all those statutes? Because that's
Right.
not fair. That's
Okay,
not
we'll have
proper.
your 5 minutes time if you'd like to start that now and present anything else you would like to present. Please present it to the panel, not to the Franchise Tax Board. I believe what they provided is a legal argument, which matches what they have in their brief as well. If you want more time to look that over after the hearing, you will have that. But as far as your presentation, is there anything else that you would like to add today?
Okay, the statement that I said, the calculation is supposed to be taxed on a 610,000, not on a 900, on a 1,200,000 or $930,000. Those numbers are not realistic because we're supposed to pay tax only on profit, not on profit. We make a profit, we're willing to pay the tax, no problem. But if we did not profit, that amount of 1,200,000 or the 930,000, that the ARG took $320,000 to pay commission that on a fake program. So we did not make a 1,200,000. We made 930,000 minus the $300,000 that was a loss. So we make actually $610,000 net, and that's what we're supposed to pay on. This, after I talked to my CPA, he said, Omer, take a look. Show me what the profit you really made. And we went over the number, and he addressed to me, Omer, you did not make 1,250,000. That's what the IRS originally taxed me on. And then we came up with the money that we got from the ARG, $930,000. We did receive it. We did. But then we lost $320,000. So to become to $610,000, tax me on that. I'd be real glad to pay every penny on the $610,000 and not a penny more. Now, since I'm a victim, a very hard victim on this system, AIG, I could not fight them. They have hundreds of lawyers that they sit up on a board there that how can I fight with them? I will have to pay $1 million to fight $1 million. And it's ridiculous. They should be penalized. They should be paying the interest. They should pay all the fees. This is not right. You take it as a citizen, senior citizen, the people, my taxman Michael Frank, that I know him for 18 years, recommend me because he was greedy to take $250,000, quote unquote, commission. So tax me on a call, not on all the issue around there. $610,000, very fair. I did make the money. I do want to pay, and not a penny more. That's the right way.
Okay, thank you. I know there was a previous OTA appeal. A hearing was held and an opinion was issued that kind of covered the issues of how much tax was owed, the penalty that was abated, whether interest could be abated. So I guess the question here is, going back to what res judicata means, it just means that the same parties arguing the same issues here, the same tax year, same interest abatement. Once the opinion has already been issued and has gone final, res judicata says you can't come back for a second bite at the apple if there's already been a sort of a competent decision on that matter. So I guess the question here is, there has been the original opinion that was issued. And what are your arguments saying that, well, we should reconsider that even though there's already a final opinion on some of these issues?
We feel that the final decision was incorrect, and then we're entitled to a addressing of this issue.
Recalculate the core amount, the real amount that we're supposed to make.
I understand that in the court, there is when it's final, but it's wrong. It's incorrect. It's being based on an incorrect number. The formula is incorrect.
We did not recover this amount until I just hired a new taxman, and the new taxman look at the total concept of the thing, and you look at the IRS, what they give it, penalize, and we said, Omer, really, tell me, you did make $1 million too? Yes, I did. You invested in energy? Yes, I did, because they recommend me the wrong program called Viva. I did. Then he's talking about how much money you got back from the energy. You got $930,000. Says me, I made $930,000 profit. Not. you have to deduct the $320,000 that you actually, they took it for me. They did. They did not give me money. And the lady addressed by name Sheila, she said to me clearly, we had to pay commission to those people that recommend me, $250,000. And she sent me a copy of it.
We feel that the justice of this issue should surpass your codes and this and that. We were done wrong. We deserve or are entitled, we feel, to some justice in the form of having the tax services, the franchise tax board, take another look, step away from their judgment because it was wrong, and we should be reheard. It's a matter of justice, not a matter of what's in your tunicata. It has nothing to do with that. This is justice. Right and wrong, justice.
All right, thank you. Let me turn to my co-panelists to see if they have any questions for either party. Judge Famularo?
Thank you, Judge Johnson. So, Ms. Katzir, I just wanted to take a moment to address one of the things that you had talked about, which was the prior opinion that was decided and the issues that were decided, and your request that that this panel revisit those issues. I just wanted to make sure that we had a baseline understanding of what we're doing here today, which is looking at interest abatement and your claim for interest abatement and the FTB's denial in their determination that you are not entitled to interest abatement. And the issue that the severed issue, as Judge Johnson discussed, that we're here to talk about today is res judicata, the legal principle about whether that interest abatement issue is barred by the principle of res judicata because it had been heard in the prior hearing. It was litigated or it was argued by you and the FTB in a proceeding before us. We had jurisdiction to hear the issue, and the issue was decided. One of the things that as a panel we wanted to ask you is, when you're claiming interest abatement from the FTB that they denied in their determination, are you requesting interest abatement for both the period that accrued prior to our final decision in 2019 and post our final decision in 2019? Does that make sense?
It does make sense, but like I said, recently I discovered that my total net profit was $610,000 after that, because I'm not a lawyer, I'm not a CPA, just an average small business people that do business, and we're lucky we had a very good year that day, and we misled it to a program that not even exists. And I strongly appeal to put them in jail, but doesn't matter. So that my net profit, and that's what I should pay tax on, is $610,000, and that's what I'm going to try to say. If I knew it before, I will tell you before, but I just discovered this particular issue. And without, the new taxman was very kind to go look over the file and say, you always have to pay what you profit on. And the profit is $610,000, not $1,250,000. But you know the good part of it? The IRS recognized it. The IRS gave us money back. They gave us hundreds of thousands of dollars back, because when we address it to them, the situation, they look at all the numbers and they look at the net profit and they tax us on the net profit, and we paid for it.
I think
Okay, so
Mr.
I'm sorry, Ms. Katzir, let me just, I'm sorry. I understood Mr. Katzir, I understood what you were saying. However, I don't feel that I got a direct answer to the question that I asked that you said you understood, which is, are you arguing that you are entitled to interest abatement, meaning that you should not have to pay interest on the deficiency amount that was decided by OTA in 2019 after the OTA's opinion was issued?
I don't feel we should pay. I think that needs to be abated because it's an incorrect amount,
Okay.
an incorrect starting amount.
Okay, no, that I appreciate that. Are you also contesting the interest that accrued prior to that decision, the
Yes.
final decision? So you are contesting both? in this
Yes.
proceeding?
Yes.
Okay.
Because it
Okay.
was not on the right number.
Okay. One other thing I just wanted to address, Ms. Katzir, you had asked how the process for appealing a decision if you're unhappy with the decision. I'm not sure if you're familiar with the process within the Office of Tax Appeals, but you can request a rehearing and you can request an appeal, but the time for that has passed. And so what we're here on today, again, is the determination by the FTB in response to your request for interest abatement that you're not entitled to interest abatement. And before we get to the merits of whether you are entitled to interest abatement, we are here today to decide whether we can even hear that issue. Again, the res judicata issue, which I know is Latin and I know is confusing, but it simply comes down to, does the prior opinion that we decided in 2019 keep us from being able to hear your arguments regarding interest abatement in this case, in this proceeding?
But if it does, then what was the purpose of this hearing? If it does, then we're not allowed to do anything and you can't do anything because you're hamstringed. What was the purpose? Why did we do this?
That's what we're here to decide. And that's the purpose of this hearing. But we all understand that that's what we're here to decide. That's what OTA is here to decide today, and that's what we're here to discuss.
Okay.
But it seems as though it's a moot point, because you're saying no matter what we say, no matter what anybody does, no matter what evidence we provide, you're prevented because of juris tomatata. Then this was just a waste of time?
What I'm trying to say, why you not calculate on the right amount?
That's not what they're talking about.
On the right amount.
Okay, that's not what they're talking about.
No, but you calculate the wrong amount.
That's not what they're talking
about. And then we did not understand what the real amount, the real net profit. But the IRS did. And when we said, take a look at it, the IRS gave us credit, and why you guys do not give us credit? And if you look one of the letter that I sent it to you, if the IRS give us a credit for hundreds of thousands of dollars, why you continue to penalize on the wrong amount? And I wrote it down, and it's a letter from me to you, and I said the IRS did, and I sent the amount of the check from the IRS to say, if they did it, and you go basically on profit, what profit we made, and the IRS say, okay, you made profit, you have to pay tax on the profit. Here's the profit, and that's what you pay. But you guys deny it. Why deny it? Why do you not recognize it? You should recognize it.
Mr. Katzir, I'm going to have to stop my questioning because we do need to move on. I do want to just very quickly address something that you just raised regarding the FTB's ability to hear something and decide something differently than the IRS did. There's case law that provides that the FTB is not bound by a determination that the IRS makes that it disagrees with. That's something that was addressed in the FTB's opening brief. But again, that's not something that we're here to discuss right now. What we're here to discuss is the concept of res judicata. And so I have no further questions, Judge Johnson, for appellants.
Thank you. I'll move on to Judge Gast.
Thank you. This is Judge Gass. I do have a question for FTB regarding our R&T section 19104B4, the last sentence that talks about the taxpayer, it says that, however, the taxpayer may thereafter request an abatement pursuant to this section limited to interest accruing after the deficiency is final, kind of referring to an OTA opinion being issued that is final, which is what we have here. And I want FTB to, if they can provide their position on res judicata and whether it applies to any interest accruing after our opinion went final September 27, 2019.
Well, just to clarify, is your question about res judicata to the interest abatement, but only for the period after OTA issued its decision?
Correct.
So, in order to not be barred by the doctrine of res judicata, a taxpayer has to establish that they presented different theories in support of the requested action. As stated in its opening brief in our statement, the taxpayers made the same assertions for why interest should be abated. In regards to the IRS adjustment to their tax liability, that would be a question of the assessed tax, which is not related to the interest abatement under 19104. So because the It's the same reasoning as presented in their first appeal with OTA back in its opinion in 2019. Res judicata would also bar because it's the same theory.
It doesn't matter.
Okay, so under 19104B4, interest abatement or interest accruing after OTA issued its opinion would be barred in your position under res judicata.
Yes, that's correct. Could be just one moment to review that section quick. I just want to make sure I'm not misspeaking on that section.
No problem. Thank you.
You know,
I have one question. What percentage?
Let's hold on for just 1 second while we finish up. We're in the middle of a thought right now, but I'll come back to you after this.
Do I need to talk?
no, we're waiting for.
So yes, that is Franchise Tax Board's position on that.
Okay, thank you. No further questions for me, Judge Johnson.
Judge Johnson, could I follow up with FTB just very quickly?
Yes, please do. And Appellants, do you mind just muting again one more time while we? Thank you.
Okay, so Mr. Garcia Rosenblum, you mentioned that is FTB's position regarding the statute. Judge Gast mentioned the very last sentence that says that appellants or taxpayer can claim interest abatement for a post-deficiency period, which is defined as after a final opinion has been issued. So what is the purpose of the statute in allowing the appellants to claim interest abatement for the FTB to issue its determination whether to allow or deny it if it's barred by the doctrine of res judicata? In particular, I'd like to draw your attention to the first part of the sentence, the preceding sentence, which provides that if a taxpayer files an appeal from the Franchise Tax Board on the protest of a proposed deficiency, and that deficiency is final, the taxpayer may not thereafter request interest abatement. But then goes on to provide that, however, the taxpayer may request interest abatement after that decision or after the deficiency is final, which here is the final decision that was issued by OTA.
Yes, so section 19104, it discusses interest abatement when there is an unreasonable managerial or ministerial delay on the part of the FTB. So after a decision is final and a deficiency is final, there could potentially be a ministerial or managerial error that causes the delay, which would essentially create a new argument for interest abatement after the appeal went final. In the current appeal, the appellants don't argue any or don't bring any new theories or make a new argument relating to the after period. They use the same arguments that were brought at the original appeal.
So I would just like to clarify, my understanding is from the request for interest abatement, the form itself provides that there is ministerial or managerial error. And they specifically request interest abatement for the period until 2022, which is after the final opinion had been issued. So we don't, what is FTB's position regarding the specific managerial or ministerial error that they're claiming? To OTA, it wasn't clear that they are relying on the same argument that they made in their first in the decision that was decided first by OTA. It appears that they're raising something now that they could not have contemplated. They could not have known at the time of the first case, at the time that it was decided. And it's also for a period that's different than the period that they would have been arguing interest abatement for in Katzir 1, and when the first case was heard.
So reviewing the request for interest abatement, the form itself, even though it mentions unreasonable error delay made by FTB, there attached documentations and arguments don't claim that there was an error or a delay that would warrant interest abatement. Instead, it discusses and even includes the same attachments that were included with the original appeal. And as for their new argument regarding the IRS adjustments, while technically not relevant to this appeal, Respondent requested an update for federal information. And based on that update in December of 2025, the only changes that were made to the IRS assessment were a waiver of a late payment penalty. And that was finalized in October 2017 before the prior appeal. So between now or that period and now, there weren't any further changes that were made.
Okay, and then I have one final question regarding the primary rights theory, which is are you familiar with that theory? It's the theory that the California appellate courts have looked at when looking at a cause of action to decide whether the harm that in this case appellants would be claiming would be the same harm that that was addressed in the prior proceeding. In this case, let me tell you OTA's view, which is that the primary harm that they requested relief from previously was interest abatement on the proposed deficiency amount in Katzir 1. And now it's a claim for refund. Is their claim for refund for the interest that they have paid both pre-Katzir 1 and that has accrued after the final decision, and includes a period which is after that final decision had been issued. I don't know if you are prepared to address this. I believe that the panel would be open to providing additional briefing on this issue if you would like. But if you have thoughts on that, I'd like for you to address it.
Yes, I'm not familiar with the primary rights doctrine, so I would be happy to provide additional information after reviewing it in additional briefing, if that were allowed. My FTB's only thoughts on that is that the goal of res judicata is to prevent repetitive suits. So allowing a claim after it's already been paid, decided for, just because now it's converted over to a refund claim, would still be a decision based off the same theory as before. So, but I'm happy to provide additional briefing just because I'm not familiar with that doctrine.
I have no further questions. Thank you.
Thank you, Judge Johnson again. I know, Appellants, you wanted to add something. I will mention right now, we only have about a minute left of this hearing, so if you can keep it just down to 30 seconds or less, that would be greatly appreciated.
One question: what percentage we pay to the FTB based on the income? On what percentage? 10%, 5%, 8%? What percentage we paying?
Are you asking for your actual tax rate for the 2007 tax year?
Yes. How much tax? What the base? What is the percentage on what amount, on whatever the amount?
Sure. I don't think that's a question that we can answer here. It's definitely not kind of relevant to what we're talking about on this. I do understand that you want to find that out. If you want to contact Franchise Tax Board after the hearing, they'll be the ones that will be best
Can
able
I
to
ask him
provide
to call me?
They're not going to call you.
Can I ask him to call me, please? 818
No.
645
This is being publicly shared, so please don't share personal information. But thank you.
Okay, I have a question. In understanding what the previous judge was stating, we can submit another appeal request based on harm and this and that. Is there somewhere I can find the proper verbiage? Because I know you guys love the proper verbiage. Where can I find the exact verbiage that I need to file a hopefully acceptable appeal letter form request to? Where can I find that?
Right. I don't think he's talking about filing another appeal, a third appeal. I think what he's talking about is if there's one appeal, is there an opportunity to file a second appeal that has a different argument or claim than the first appeal had, is covering a different harm, let's say. So that is what we're talking about here with res judicata. So this is the appeal that would have been filed. So you're already on that track right now.
So there is no other avenue for us. This is it.
This is what you want to focus on, yes, at this point. And I'll provide you the 30 days after this hearing. You can review FTB's materials, think about what was discussed today, provide anything in addition that you'd like, as well as any objections you might have to their exhibits if you think for whatever reason they're not relevant for our decision here. I'll also leave the record open 30 days for Franchise Tax Board if you want to investigate any further the questions that were raised today as well and provide a brief on that. I'll provide orders after this hearing that will lay out the 30-day deadline for everybody.
Will I be receiving that by email or I have to go to the OTA portal?
It should come to you through the portal. Would you like it through email instead, or are you able to use
Yes,
the portal?
please. I would like it through email.
All right, thank you. Well, I'll make sure that happens for you.
Mhm.
Okay. With that, we do have evidence that's been submitted into the record. We have your arguments and your briefs, as well as oral testimony arguments presented today. As I mentioned, we'll leave the record open for 30 days for both parties to provide additional submissions. After that time passes, we will close the record. I wish to again thank both parties for their efforts in this matter. This concludes the hearing for this appeal. The parties should expect a written opinion no later than 100 days from the day the record closes. And this is a separate issue, so if that opinion does not cover all live issues for the appeal will continue. If that does resolve everything, that will be the end of this appeal, barring any petition for rehearing process. But you will receive further documents explaining all that to you.
Okay.
With that, we are now off the record. The next OTA hearing on a separate matter will begin in approximately 5 minutes. So I want to thank everybody today for joining and have a great day.
Thank you.
Thank you.